Good afternoon. Hello, I'm Kevin Vance. I'm the director of the Center for Constitutional Liberty, and this is our last public lecture for this semester, so thank you all for coming. And today we're hosting a speaker who's a participant in probably one of the most important political, legal debates going on right now, especially in the kind of Catholic intellectual world. And so I think this is a really exciting moment for the college to be part of this debate. And I'd like to introduce a constitutional fellow to introduce our speaker. The lecture for this semester, so thank you all for coming. And today we're hosting a speaker who's a participant in probably one of the most important political, legal debates going on right now, especially in the kind of Catholic intellectual world. And so I think this is a really exciting moment for the college to be part of this debate. Who's currently studying, and I'd like to introduce a constitutional fellow to introduce our speaker. The lecture for this semester, so thank you all for coming. And today we're hosting a speaker who's a participant in probably one of the most important political, legal debates going on right now, especially in the kind of Catholic intellectual world. And so I think this is a really exciting moment for the college to be part of this debate. Who's currently studying, and I'd like to introduce a constitutional fellow to introduce our speaker. The lecture for this semester, so thank you all for coming. And today we're hosting a speaker who's a participant in probably one of the most important political, legal debates going on right now, especially in the kind of Catholic intellectual world. And so I think this is a really exciting moment for the college to be part of this debate. Who's currently studying, and I'd like to introduce a constitutional fellow to introduce our speaker. The lecture for this semester, so thank you all for coming. And today we're hosting a speaker who's a participant in probably one of the most important.
Current research projects include exploring executive dominance in contemporary constitutional systems, the role of government plays in bolstering executive power, and the application of principles of the classical legal/natural law tradition to contemporary public law questions. Casey has had work featured in journals like the Modern Law Review, Maryland Law Review, Edinburgh Law Review, the International Journal of Constitutional Law, and the European Constitutional Law Review, Public Law, the Harvard Journal of Law and Public Policy, and Law and Literature. Casey's work has been cited by the Irish Supreme Court, Court of Appeal, and High Court. In the United Kingdom, Casey has given expert evidence to the House of Lords Constitution Committee, and his work has been cited before the House of Commons Justice Committee. Please join me in welcoming Professor Casey.
Thank you very much, John and Kevin, for the introduction and for the kind welcome that every person I've met at Benedictine has given. I'm just thrilled to be here. Thrilled to be here with you all at the Constitutional Center for Liberty. And I'm thrilled for several reasons, actually, some of which might surprise you. Obviously, as a scholar working in the natural law tradition, I'm thrilled to be speaking at a college whose ethos is so infused with pursuit of what is true and good, to invoke your motto, striving forward, always forward toward these fitting ends. But I also have more personal reasons for my delight. You might think, reasonably, that an Irish law professor who works at the University of Liverpool would be stepping into new territory by coming to Atchison, Kansas. But you would be wrong. I can proudly boast that not only have I been to Kansas on many occasions, and not only do I enthusiastically support the Chiefs when occasion arises, but thank you, but I am engaged to a Kansas City native who owns a farmhouse in Atchison to boot. So in many ways, I consider myself very much on home soil here at Benedictine amongst my fellow Kansans. This evening, I'm going to be talking to you about common good constitutionalism, which is a natural law approach to thinking about the nature of law, its purpose, and then more specifically, how we might begin to approach central questions of public law, like legal interpretation and institutional design. My talk is entitled Common Good Constitutionalism, What It Is and What It Is Not, and will involve me working through 5 critical propositions made about common good constitutionalism, and they are that, first, common good constitutionalism is an American political phenomenon and results-oriented project. 2, the common good constitutionalism is utilitarian and majoritarian. 3, the common good constitutionalism swaps law and legal texts for moral decision making, so it swaps law for morality. 4, common good constitutionalism promotes judicial supremacy. And 5th and finally, the common good constitutionalism is disdainful of rights, whether constitutional, human rights, or natural rights. Each of these 5 propositions speaks to a characterization of common good constitutionalism that I suggest is false and wide off the mark. By moving through each misplaced proposition that concerns what common good constitutionalism is not, I offer in their place a more accurate restatement of what it is. Proceeding by this route, I hope to finish my talk having presented a clearer picture of what this classical legal revival is all about, and why I think it is a more compelling and true way to approach, for natural lawyers in particular, to approach questions of law and legal interpretation. So the first of the 5 propositions I will try to grapple with and rebut. This is the longest one, so bear with me. The other 4 are shorter. The first proposition is that common good constitutionalism is an American political phenomenon, rights or results-oriented project. Debates over constitutional theory rarely make a big public splash. Outside the staid confines of academia and think tanks, people simply have better things to do than peruse the pages of law reviews for the latest professorial back and forth. Hard to believe, but it's true. However, in March 2020, Professor Adrian Vermeule of Harvard Law School would break this general tendency in rather spectacular fashion with the publication of a series of short but incredibly sharp essays in The Atlantic and the legal theory blog Jus and Justidium, advocating a seemingly radical proposition that jurists, particularly conservative jurists, should abandon originalism and embrace an alternative approach to constitutional interpretation, one more explicitly aligned with and conducive to securing the common good. Rarely have such short essays about constitutional law sparked such a fevered response. Immediately after its publication, a sprawling debate grew, and battle was soon joined by interlocutors from every school of legal thought. Reactions ranged from the sympathetic to the heated, and unfortunately, the histrionic. Accusations of authoritarianism, even fascism, were casually leveled. As was innuendo, Professor Vermeule's arguments were merely an insincere intellectual veneer for using the federal judiciary to legislate preordained results from the bench. The battle over common good constitutionalism has so far largely centered in the United States, with growing side skirmishes in the United Kingdom and Canada. But it would be a serious error to assume the fundamentals of this debate are confined to questions of interest to American jurists, political actors, and citizens. Because in fact, common good constitutionalism is only an American phenomenon and project in a very minor sense. It is American in the limited sense that debates internal to the United States provided the immediate catalyst for Vermeule's arguments. This is not at all unusual in the history of legal theory, because legal theories tend to emerge and re-emerge, ebb and flow in response to concrete political circumstance. For example, it is no coincidence that the horrors of the Second World War inspired a revival of the natural law tradition in the 1940s and 50s. Horrors that were, according to natural lawyers, driven in part by the political abandonment of the notion that there were intrinsic moral limits on lawful state action and the competency of political authorities over individual and familial life. In the United States, the work of the Warren and Burger Court era Supreme Court helped generate a significant amount of legal theory. From Alexander Bickle's counsel for the Supreme Court to proceed in its work with Berkey and Caution, to John Hart Ely's influential political process theory that tried to legitimize much of the work of the Warren Court as democracy promoting. And perhaps most significantly, the Warren Court no doubt helped spur the rise of originalism, a theory which clearly attempted to reach above the heads of the Supreme Court to a higher source of authority in we the people, the original meaning set by the popular sovereign. Similarly, I suggest present-day U.S. political and legal debates served as the efficient cause, sparking Professor Vermeule's call for rejection of the jurisprudential status quo. On my reading, the straws that broke the camel's back involved several factors hitting around the same time. The Supreme Court's decisions in Obergefell and Bostock clearly played a part. So too did the increasingly conservative-dominated federal courts' faith-like embrace of originalism, which wedded them to an interpretive theory seemingly, in some iterations, proud of its agnosticism to the good at the point of application. Moreover, it no doubt weighed in Professor Vermeule's mind that originalism had proven itself not only agnostic to the good, but infinitely malleable, such that its most cited academic proponents like Professor Jack Balkin or Professor Stephen Calabresi could entirely, in good faith, argue things like abortion and same-sex marriage were constitutionally required by the original meaning of the text, understood at a sufficient level of abstraction. Of course, Professor Vermeule believes, as do I, that originalism's pretensions to exclude considerations of political morality at the point of application have always been bunk, for the simple fact that appellate courts, like the Supreme Court, invariably rely on those very considerations to aid their interpretation of often vague constitutional text, or to identify the precise level of generality required by the original meaning of vague texts like liberty or due process. In recent years, this fact has been very prominently featured in cases involving the administrative state, separation of powers, and federal regulation. And it no doubt soured Professor Vermeule's mood further when, in these kinds of cases, the Supreme Court inevitably read sparse constitutional text concerning the separation of powers in light of distinctly modernist, libertarian moral concerns to cabin the federal government's capacity to act and to project public power. These incidents altogether, I think, supplied enough pounds of pressure to trigger Professor Vermeule's now famous essays, or infamous essays. But while this context is the likely efficient cause of the emergence of common good constitutionalism, it is not its formal cause or final cause. Common good constitutionalism is not linked to a particular political party or platform. It is not a wish list of positions on contested matters of interpretation or precedents of the kind judicial nominees these days must promise implicitly to deliver on before being nominated by a Democratic or Republican president. While it certainly has things to say about contested legal issues, it is not a political plan B to originalism, a crib sheet of answers to be wheeled out opportunistically and distributed to judges now that the federal bench is well stocked with young conservative jurists following the Trump administration. Well, if it's not American or a results-oriented project, then what is it? Common good constitutionalism is first and foremost a theory of the nature of law, grounded in the classical natural law tradition of Aristotle, Cicero, Ulpian, Gaius, Aquinas, and more recently the likes of Heinrich Riemann, Jacques Maritain, and Charles de Koninck. It is a theoretical outlook on law that transcends the particularities of specific legal systems and the context and time-limited nature of debates within them. Common good constitutionalism is dedicated to reviving an immemorial way of viewing the purpose of law and its relationship to public law and the common good. A thumbnail sketch of the intellectual foundations of this tradition, and thus of common good constitutionalism, is now warranted. And for anyone who wants a deeper dive, I suggest you go out and buy Professor Vermeule's new book. And no, I don't get any royalties for that. I just encourage it for your own benefit. But I'll give a thumbnail sketch of three central tenets of the classical tradition. I'll talk about what it views the point of law as, the different senses of law in the classical tradition, and then how posited law, that is, law enacted by human authorities, actually helps promote human flourishing. So I'll talk about the point of law first. Law in the classical legal tradition is understood, as St. Thomas Aquinas famously framed it in his treatise on law, as an ordinance of reason promulgated by political authorities for the common good. It takes the view one only truly understands the nature of law after grappling with its moral point or purpose. Only by knowing the moral point or purpose of law as a distinct kind of social practice, can we pick out its richest sense, its richest example, what scholars call its central case or focal case? Use of focal case methodology of the kind deployed by Aristotle and more recently by the likes of Professor John Finnis requires a social theorist, like a legal scholar, when they're talking about law, to move beyond simply reporting how people in this or that community talk about a phenomenon like law at a given time or place, and to instead strive to offer the richest account of that social phenomenon they can pick out. An account rich enough to accommodate the good reasons people have for engaging in that type of practice, a practice like law. And the classical tradition adopts the premise that the good reasons people, all of us, have for establishing and upholding a system of authoritative rules and ordinances that coordinate our action in community are linked to the promotion of human flourishing and common good of a polity. The idea that there are certain types of human good and communal good that can be secured only through law as a type of social ordering. So it takes the view that law is critical to overcoming the deficiencies we can associate with the contentiousness and arbitrariness of pre-legal community in a more morally sound way conducive to our good than relying on other forms of social ordering like gangsterism, warlordism, or naively hoping for extended social unanimity. These are the basic types of reasons of morally reasonable citizens and officials in a political community which can actually bring things like legal systems and constitutions into being and sustain them as social practices and institutions for regulating communal life over time. In contrast, for the evil man, securing their aims by resort to extra-legal method, like sheer terror, or half-hearted dedication to law, cynical dedication to law of a large sprinkling of extra-legal terror, these are much more efficacious ways to their ends than establishing genuine adhering to a legal system of authoritative rules and ordinances. So to count as law in the richest sense of that term in the classical tradition, a posited ordinance, a law made by human authorities, must rationally conduce to the good of the community for which the lawmaker has a duty and a privilege of care. And just like how a dishonest friend is no true friend, quack medicine is not real medicine, or illogical ramblings and half-baked arguments are not real arguments, so too an unjust law misfiring in this regard by not rationally conducing to the common good is not a law in a central, richest case, but a diluted, impoverished example, what Aquinas calls a perversion of law, such that while it may be called law and enforced as law by courts and officials, is in the eyes of the classical tradition morally more like the exercise of bare force. So that's how the classical tradition understands the basic telos and point of law as a practice. The classical tradition carefully distinguishes between two senses of law a community will have: lex and jus. Lex is the enacted positive law that is created by human decisions, like the Constitution, statutes, executive orders, judicial precedents. Jus is the community's overall body of law, including and subsuming lex, the enacted texts, but also containing general principles of jurisprudence and political morality that flow from the basic precepts of the natural law. And for the classical lawyer, both lex and jus are critical to securing human flourishing. A brief note on human flourishing. What do I mean by it? There's an extremely rich and extensive philosophical debate in the natural law tradition I cannot do justice to, both for reasons of the limits of my professional competence, especially in a room full of esteemed philosophers and theologians, and partly due to time constraints. But it is suffice to say there's clear agreement in this tradition that it approaches human flourishing with different assumptions in some contemporary strands of liberal jurisprudence. So, for example, human flourishing in the classical tradition starts from the premise there are ends and goods objectively constitutive of human flourishing, human happiness, and well-being, and that these goods and ends are instantiated by acting consistently with the precepts of natural law. whose most basic and self-evident injunction is that good is to be done and evil to be avoided. And the goods central to human flourishing, to which we are normatively naturally inclined, include things like life and its component aspects of health, bodily integrity, safety. We're inclined to the creation and education of new life, to friendship in its various forms, from neighborliness to its richest sense in marriage, to living in accordance, to living in a well-ordered, peaceful, and just polity, and to pursuing and living in accordance with truth, including ultimate truth. Our instantiation of these goods and ends in community constitutes our perfection and fulfillment as rational, social, and political animals, whereas their destruction or degradation frustrates this fulfillment. Okay, so much for the basics of the point of law and the different types of law and what I mean by human flourishing. The final basic precept of the classical tradition I want to talk about is how posited laws enacted by human authorities actually help promote human flourishing. Perhaps contrary to popular understanding of the natural law, the classical tradition has always recognized the utter centrality, the utter indispensability of positive law created by human authorities to securing human good and flourishing. So, positive law acts as a reasoned ordinance in several ways when you drill down. And I'll talk about three different ways. The first way is that positive law is critical to make more concrete the broad and vague requirements of the natural law. The natural law serves as the basis or foundation stone of the entire juridical order of a community, but it demands greater specification in any given community through positive enactments, through human law promulgated by acts of human will and creativity, cabined and guided by the natural law and right reason, but rarely dictated. Aquinas says natural law becomes posited in human law in two ways. The first way is that some precepts of the natural law can be concretized in positive law via a straightforward enough deductive process. For example, the preservation of life is an aspect of human good and principle of the natural law. This yields easily enough the conclusive precept against the intentional taking of innocent life that is easily posited in human law through laws prohibiting homicide and allowing for self-defense, for example. But Aquinas says the concretization of the principles of natural law is typically much less simple than this, as natural law's first precepts are broad and vague, like I discussed, respect for life and sociability and marriage and things like that. So respect for natural law principles and the common good may demand, for example, creation of lawmaking and applying bodies to resolve disputes peaceably, organizing a just economy able to provide the necessities of life, respect and support for subsidiary units like the family, the prudent promotion of virtue, the promotion of peaceable relations within a polity and between polities. The natural law may require all these things, but there are countless ways to proceed in all these areas, with the natural law not pinpointing a specific approach to any of them. So the natural law offers a skeleton law to communities, which determines what human arrangements, what positive arrangements are just and right. But to enjoy concrete existence, natural law requires the sinew, flesh, and muscle provided by positive law, enacted through human creativity and discretion. This is what Aquinas dubs determination, the process whereby a political community specifies how it's going to respect the precepts of natural law and to promote human flourishing, hopefully prudently in light of their own concrete circumstances and needs. So that's the first reason that law can act as a reasoned ordinance for the common good. The second way positive law can act as a reasoned ordinance is by providing authoritative direction to a community in its pursuit of the good. Unanimity on how to pursue the common good is impossible in a society of any complexity. So political authority is required. Making concrete the open-ended demands of human flourishing in a community in the here and now, demands of peace, justice, abundance, requires the coordination and ordering of persons, families, and associations. This ordering ensures that pursuing conditions of peace, justice, abundance is done prudently, efficaciously, and harmoniously, and not in a chaotic, disordered manner. So posited law promulgated by political authority who have the capacity to ensure the ways and means of coordination is done effectively and prudently is critical for communal good. So that's the second way a positive law can act as a reasoned ordinance. Finally, and contrary to some contemporary libertarian views of law perhaps, in the classical tradition, legal ordinances are emphatically regarded as having a critical pedagogical function. Positive laws can and do encourage citizens subject to the law to form certain desires and habits and eventually beliefs. The state and its laws, says Professor Thomas Pink, are a coercive teacher. For the classical lawyer, laws should be used to prompt citizens to act in a way and eventually form beliefs that better track and promote communal and personal well-being. This, of course, is an important, but of course a subsidiary role, complementary to, and not usurping of, the primary role played by the family, churches, civic associations, and local communities. It is also a role that must be handled prudently, and with awareness that sometimes toleration of social vice is the most sensible course of action to avoid greater harm to peace and order. As Aquinas himself noted, people are best brought to virtue through the rough engine of positive law, gradually, not suddenly. So those are just some basic building blocks of the classical tradition. So law, says the Spanish jurist Javier Hervada, is the art of leading society to the common good. And it is precisely lexes, the enacted positive laws, critical role in making concrete the detail of the natural law, directing and authoritatively ordering a community in its pursuit of the good, and helping prudently promote virtue. This is how it concretely acts as an ordinance of reason. And this is what generates our normative obligation to obey the law. So this whistle-stop tour through the classical tradition and its treatment of the nature of law, I hope, conclusively should dispel any perception Professor Vermeulen and others, myself included, are engaged in a narrow political project whose aspirations are entirely or primarily practical. Common good constitutionalism is first and foremost a speculative project which tries to articulate a true and compelling account of the nature of law, on which then we can better anchor constitutional politics and how we approach public law. So that's the first proposition, and the rest are shorter, I promise. So the second proposition is common good constitutionalism is utilitarian or majoritarian. You'll have noticed that phrase, the common good, keeps coming up again and again. But what do I mean by it? Let me start, if I might, by clarifying what I do not mean. One encounters the objection that the phrase, the common good, pertains to the political community viewed as some sort of organic whole, where individual persons exist for the good of the state, as one might say bees relate to the hive. That is, critics see the word the common good as the good of the collective, or even worse, the good of the state apparatus. And then they oppose this collective good to the good of individuals. And these variants of critique, the common good, even invoking the common good, is viewed with deep suspicion as an appeal to blunt majoritarian force, which is external to the good of individuals, something that is harmfully imposed upon them. This is not the classical account. In classical theory, the ultimate, genuinely common good of political life is the happiness and flourishing of the community, the well-ordered life in the polis. In simple terms, it is the structural, political, economic, and social conditions that allow communities and the individuals within them to live in accordance with the precepts of justice that secure human flourishing. It is not the sum of individual goods, but the indivisible good of a community which enjoys goods of peace, good order, and justice, that belongs jointly to all and severally to each, and is not diminished in being shared, but further diffused. So it's not that private happiness is the real aim of political life, and the public realm is merely what supplies the conditions for it, like lawful peace, stability. rather the highest felicity in the temporal sphere for individuals, is itself the common life of the well-ordered community. So human flourishing in this tradition is itself essentially, not merely contingently, dependent upon the flourishing of the political community within which we humans are always born, found, and embedded. Our flourishing in community is bound to our conjugal nature, or orientation to family, our social nature, and indeed our political nature. Our need for political community in this tradition is attributed partly to not having the things we need to survive and live well by ourselves, or in family units, or small collections of family units. For example, lacking the material conditions for physical and psychological integrity, and the deep stability of peace guaranteed under law. These are things we lack and need to live well. But as Eve Simons pointed out, our needs for political community are not merely materialist ones, but also include our need to give of ourselves to others, to be generous, to act benignly, to share our talents, skills, and accomplishments with our fellow man. Needs that can only be fully expressed in a well-ordered political community, as opposed to a fractured, paranoid, decaying one. This reality, I think, is the backdrop to Aristotle's observation that anyone who does not exist in society or has no need of it is either a beast or a god, not fully human. The common good of a political community is therefore not separate from the good of its individual members. As such, no subordinate goods can be fully enjoyed in a dysfunctional political community. The loving family or the virtuous individual cannot fully flourish in a political community that is tyrannical or depraved, and where human good is degraded by, for example, rampant pollution or poverty or racial hatred. All of this is not to say, of course, that the individual should be absorbed into the political community. As Aquinas reminds us, man is not ordained to the body political according to all that he is and has. The end of the community is ultimately to promote the good of individuals and families. And part of this involves respecting individual and familial rights, the claims they are owed in justice for them to truly flourish, which put limits on legitimate state action. I'll speak to this in more detail a little further on. Political authority must also have regard to the principle of subsidiarity. That is, the need to respect the authority and integrity of part wholes of the polity, like individuals, families, associations. The principle of subsidiarity can be seen as both empowering and constraining of public authority. It does the former, the empowering, by giving it a power and duty to preserve, protect, and restore the functions of subsidiary authorities, and the latter, the constraining element, by putting a duty on it not to interfere where unnecessary when subsidiary groups are working as they normatively should. This understanding of subsidiarity, however, is not a species of argument for limited government in a classical liberal or libertarian sense of that term. Instead, it justifies limits on proper state action from the fact we flourish best as individuals, families, associations, and overall as a polis, when the part wholes of our community are allowed to act and develop according to their own unique abilities, competences, interests, talents, and structures, without unwarranted direction from a higher political authority. Justification is not autonomy or liberty or efficiency as goods in themselves, but how these particular liberties and autonomy for part wholes conduce to the good of each and all. So as you can see from this is all very far from majoritarianism or utilitarianism on any reasonable reading. Third proposition, common good constitutionalism displaces legal text with morality. It swaps law for morality. As noted, the classical tradition regards a community's overall body of law as containing both principles of use, which come from the natural law and its basic precepts, and the law enacted by human authorities, by legitimate political authorities, what the classical tradition calls lex. So lex in use. An important question for all jurists and officials then is, how do use and lex interact in legal interpretation? Here's some caricatures need clearing up. For a start, legal interpretation in the classical tradition does not depart from the text or substitute morality for law. The classical tradition entirely accepts that legal interpretation of things like constitutions will not involve all things considered moral argument from first principles. As just discussed, the classical tradition in fact puts enormous stock on the need for posited law for reasons of settlement, stability, and coordination. This yields a few basic premises for how classical lawyers approach interpretation. A starting point is to say that all officials are bound to faithfully adhere to and interpret the meaning of constitutional or statutory provisions posited and fixed by legitimate political authority, unless and until those provisions are lawfully repealed or replaced. This means the tradition is emphatic that interpreters of the law, such as judges, ought not to displace the posited law by reference to all things considered moral decision-making. They don't set it aside and say, I will decide this according to my own reading of natural law. I know better than the legitimate authority. So in a sound legal system, legal interpretation will invariably become more technical and less radically creative the further officials descend from giving effect to the most general principles of use via fundamental determinations like creating a constitution, to making still broad but more specific determinations for the common good via legislative or executive enactments within the constitutional order, to finally resolving quite concrete legal questions via adjudication between parties. As one descends from the most fundamental determinations and comes closer to the resolution of individual concrete cases, legal interpretation in a sound legal system will increasingly be channeled through an often technical web of rules, standards, precedents, canons, and doctrine, the standard fare of lawyerly work. Where the classical tradition's approach to interpretation differs from contemporary textualists and originalists is that it rejects the idea that following the law is synonymous with following the ordinary meaning of a legal text. It flatly rejects the notion of Justice Gorsuch and Bostock that, quote, only the written word is the law. The classical lawyer rejects the idea our law is exhausted by the ordinary meaning of texts, but insists that our law also includes considerations of use. This does not mean the principles of use are invoked to set aside the posited law. Instead, classical lawyers look to general principles of the nature of law and political morality precisely in order to understand its meaning, the meaning of posited law, as an ordinance of reason embodying reasoned choices of the lawmaker. So instead of approaching legal interpretation by stipulating circular definitions of law, which confine it to the text alone, classical lawyers must justify the standards, presumptions, and interpretive canons that guide the work of judges and officials before the bar of the common good. For instance, by appealing to the relationship of these technical rules and determinations to goods like stability, predictability, continuity, and respect for appropriate institutional role morality, all of which can conduce to the common good. So a classical lawyer could, hypothetically, be entirely comfortable with, say, a form of presumptive textualism in the ordinary run of cases, and uncomfortable with a loose form of purposivism where the judge strains the ordinary meaning of a law to reach a reading they think is best. But the classical lawyer will justify each of these attitudes not by uncritically stipulating that the ordinary meaning of text is all the law that matters, but because of how these kinds of approaches can conduce to the common good or not. In other words, it is uncontroversial to say that respect for posited text is critical. The more difficult question, the fighting question for jurists, will always be deciding how best to respect the choice and intent of the legitimate authority in positing what it did posit. And the classical lawyer will argue this kind of decision must be justified by additional arguments from political morality, and not by insisting that the ordinary meaning of text itself exhausts our law. Additionally, while the classical lawyer understands the great run of ordinary cases, day-to-day cases, can be decided without direct recourse to principles of use and political morality, they can be run through the technical rules and webs of legal rules that lawyers tend to use. They also emphatically accept that these principles of use, can never entirely be excluded from interpretation of legal materials. Jurists as diverse as Aquinas, H.L.A. Hart, and Ronald Dworkin have recognized there inevitably will be questions about the meaning of lex, of posited law, in a range of hard cases. When might this be? Well, perhaps due to the limits of lawmakers' or founders' foresight, you might be faced with a legal text, usually a constitutional text, that is shot through with ambiguity, that can be read at multiple levels of generality. Just consider provisions invoking things like liberty, equality, general welfare, commerce, or you have provisions which might seem to conflict with powerful principles and background norms of the legal system, or which at the point of application seem absurd if applied to unusual circumstances. In all these run of cases, these hard types of cases, a question might arise about how legal sources of the posited law lex and the principles of use are to be reconciled and applied. For the natural lawyer, it is on these occasions that legal materials like constitutional text must be interpreted in light of background principles of political morality. This is utterly inescapable, and the real question is not whether principles will serve as an interpretive aid in hard cases, they surely will, but rather whether the principles drawn upon are morally compelling or degrading, whether they help us understand the posited law as an ordinance of reason or as a perversion of reason. For the classical lawyer, the principles to draw upon will be those of the natural law, the ends of rightly ordered law and government. So this has a distinctly Dworkinian flavor, given it involves reading underdeterminate legal materials in light of principles of the natural law that fit them and justify them. Such principles include, as I've already mentioned, respect for human life, health, pursuit of the truth, solidarity between and amongst citizens and families, and appropriate respect for subsidiarity. This kind of interpretive exercise has always been the key role of natural law in both theory and historical practice. Its central use is not to be invoked to set aside posited law, but to better understand posited law as an ordinance of reason for the common good. Okay, penultimate proposition. Common good constitutionalism advocates judicial supremacy, or executive supremacy for that matter. So there is an argument one hears made that common good constitutionalism is somehow synonymous with judicial supremacy or executive authoritarianism. There's simply no substance to these kinds of arguments. Recall that earlier I spoke about how the concept of determination is critical to the classical legal tradition. That some facets of the legal system are simply not dictated by the natural law or reason, but involve human creativity and prudence and discretion. This emphatically includes determination at the level of institutional design of a constitution, indeed the specification of the whole constitutional order, because the natural law does not compel one form or another. The design of institutions and how you allocate authority between those institutions will therefore be within a wide scope of reasonable determination. A range of regime types can be ordered to the common good or not. If they can be ordered to the common good, then they are just. If they're not ordered to the common good, then they're tyrannical in the classical sense. But their justice is not defined by or inherent in any particular set of institutional forms. That means that parliamentary, semi-presidential, presidential, monarchical, republican, all these and more can in principle be ordered to the common good. Common good constitutionalism also takes no stand, a priori, on the well-worn and exhausted debate over the virtues of political constitutionalism versus legal constitutionalism. So if you have a constitutional order where judges are bound to respect reasonable determinations in the public interest by the political branches, maybe even political branch decisions about how to interpret the Constitution, this can be entirely conducive to the common good, as can a system with no judicial review of legislation whatsoever, like the system in the United Kingdom with parliamentary sovereignty. All of which is to say it takes serious illiteracy about the classical legal tradition to suggest it mandates a form of strong judicial supremacy where judges can willy-nilly overturn legislation as is inconsistent with the court's own understanding of natural law. It is not mandated whatsoever. This broad agnosticism to forms of regime types doesn't mean there are no boundaries whatsoever. It just means that the boundaries are not set. It means the boundaries are set by the nature of law itself as an ordinance of reason to the common good. So there will be certain institutional arrangements, mostly, thankfully, dystopian and horrific, like absolute dictatorship, they'll be clearly ruled out as unreasonable, even if no one set of arrangements is uniquely specified. To be sure and to be candid, both Professor Vermeulen and myself are sympathetic to the view there are forms of constitutional ordering centered on robust executive government that are likely to be particularly conducive to pursuing the common good under contemporary socioeconomic conditions that face countries like the United States or Ireland, for that matter. But crucially, the sort of view we hold, this is not dictated by the classical legal tradition. Questions of institutional design are largely prudential ones on which reasonable minds will differ, guided by the concept of determination, after careful consideration of which form of institutional structure is most suited to securing the common good in a particular polity in light of its circumstances. On this, reasonable minds will differ, and what matters is we're all approaching these questions aiming for the common good and not a myopic end like safeguarding individual liberty and property above all things. Fifth and finally, common good constitutionalism is disdainful of rights. In responding to this mischaracterization, I can speak plainly. Rights, properly understood, are critical to common good constitutionalism. The crucial distinction between classical legal and some modern liberal juristic conceptions of rights involves the question of their justification. What is the justification for rights? That is, whether their purpose and point is articulated in individualist terms or instead in terms of the common good, which is discussed as also the good of individuals. For example, property or speech rights may be justified either on individual and autonomy-based grounds or instead on grounds that emphasize their potential contribution to the flourishing of the community and the part wholes of that community. For example, take speech. Speech can be justified due to its contribution to pursuit of the truth, to seeking truth, and to holding public power to account and deciding who to appoint to wield public power. And the same with property. Property can be justified on the basis of its contribution to the stability of family life, to creativity and ingenuity that it promotes, and to goods associated with subsidiarity. On the classical conception, rights are jura, because jus is justice, affording to each what is due to each. Crucially, what is due to each, to individuals, families, associations, on the classical view, is itself determined by the common good, right from the ground up. Rights are due, they're owed to persons and families as they are states of affairs and arrangements within a polity that are just. They're in the right, and they help conduce to the flourishing of each and all. And this is where the contrast with prominent strands of liberal legal practice and theory is critical, because in many mainstream liberal accounts of rights, it's respect for personal autonomy, for individual self-determination, that is increasingly regarded as the conceptual anchor for rights, powers, and liberties. The need to respect autonomy and self-determination and self-realization in practice often ensures the scope of these rights is interpreted in an expansive and open-ended manner by courts, even extending to recognition of rights claims to engage in activities that are flatly corrosive to human good and to society. In many legal systems as well, after a court fixes the scope of the right, it proceeds to probe whether the exercise of that right has been subject to justifiable interference by the state to balance conflicting rights or to advance collective goals in the public interest. So once you find the scope of the right, then the question is the state's interest enough to outweigh the right? That's a common way of how courts resolve rights disputes in America and Europe. A striking aspect of this way of conceiving of rights and their limits is that it puts rights squarely in tension with the common good, and it puts the good of individuals in square opposition to the common good of the polity. Talk of balancing collective and individual interests is endemic to liberal conceptions of rights, but again, as with taking an autonomy-centered approach to the purpose and point of rights, this too is a serious departure from the classical conception. The classical conception of how to understand rights and their limitations would be entirely different. For a start, on the classical understanding, the common good would enter into the very definition of rights themselves from the beginning. There's no question of overriding or interfering with the rights of individuals and families, what is due to them in justice for the common good. Rather, Professor Vermeulen correctly notes that the key conceptual question is one of tailoring the scope of rights to the common good, because that is their very justification that animates those rights at every stage. But the fact that rights must be ordered to the common good of each and all also means that the Act is very real limitations on legitimate exercises of state power, limits stemming from the need to give to each what is their due in order to have a well-ordered and just polity. And to overstep these limits would be contrary to the common good and unjust. Intrinsic evils are intrinsic evils, and no government may command them, which includes absolute prohibitions on evils such as intentional killing of the innocent, torture, rape, or slavery. And as already discussed, there are also limits on the scope of reasonable determinations by the state that stem from a need to respect more open-ended but still important principles, like the need to respect subsidiarity, and the fact families and associations have, as Heinrich Rahman put it, partial ends of their own which cannot be permanently absorbed by the higher community. For example, it is not within the legitimate scope of state power to usurp the primary role of parents as the natural educators and guardians of their children, even if the political authority does have the duty to intervene when parents are seriously delinquent in this duty. So again, properly understood rights are critical to common good constitutionalism. So let me tie everything together now, and thank you for your patience. I've tried this evening to give a clearer picture of what common good constitutionalism is all about. I hope I've made some headway in convincing you, or more specifically, those of us committed to the natural law tradition, of its merits as a compelling and true way to approach questions concerning law's nature, its point, and how these relate to more concrete questions such as legal interpretation. As for the future of common good constitutionalism, I offer no firm predictions about its immediate prospects for practical impact among students, lawyers, officials, and judges. But I can say I am quietly optimistic and heartened by green shoots already visible. As for the long-term prospects of the classical legal tradition in the United States and elsewhere, I close by adapting the wise words of the fictional chaos theorist Dr. Ian Malcolm of Jurassic Park fame, and offering the suggestion that history has shown us, time and again, that the natural law, like life itself, finds a way. Thank you very much.
All right. We have some time for, is this on? This mic? Okay. We have some time for questions.
Is the proper agent of the classical theory you talk about, or natural law, the legislator, the jurist, or the citizen? Or way down low, the professor?
Yeah, professor's definitely at the bottom of the pile. I'd have to agree there. I think that natural law, in order to be the lifeblood of a legal system and the water in which the lawyers and judges swim in, has to have a critical, at least minority support and fluency with citizens, with officials, with judges. Natural law binds and applies to everyone, and there is a division of responsibility for how to promote it among different actors. But reflecting on my own jurisdiction, we went from a situation where natural law was the dominant interpretive methodology from 1950s until 1990, and then disappeared like that once people just stopped citizens, government officials, judges stopped adhering to it. So everyone has a different role to play, but I think that you need some type of critical minority, at least, who believes in its precepts to get it off the ground and embed it in a community.
I'll bring it over to you.
So regarding the last bit about rights as and their place within common good constitutionalism. So I know you make a distinction between rights being justified on individual grounds versus rights being justified on community grounds. Could it be said that another common good justification for rights is that there are certain actions that are necessary not only for communal happiness but also for individual happiness? Right, you know, things like the ability to get married and have children and all of these goods that are necessary not just for communal life but also for individual life. I think you could conceive of these as a certain form of human rights that the state can never infringe on, or can they? I guess my question is that a valid way of conceiving of rights, or is that in your mind a little too on the liberal libertarian side?
No, not at all. Rights affording to what is due to individuals and families as a matter of justice to allow them to flourish in accordance with the precepts of natural law is a critical aspect of the common good. You cannot. I have a friend, a professor in the University of Strathclyde, Michael Foran, who notes that the means to get to the common good are as critical as the ends. You know, he said you can't torture your way to the common good. In acting in an intrinsically evil manner, you're in itself acting unjustly, and this would be the same with you couldn't abridge basic natural law precepts and basic things that are owed in justice to people in order to get to the common good. That's a contradiction in terms. Those must be respected in order to have a polity that you could say is in any way oriented to the common good. I'm glad.
I came in with Dworkin on my mind, and you mentioned him, and he brings up what might be a big challenge practically for common good constitutionalism. He says, well, why are there conservative and liberal justices? Shouldn't we just have the law? Well, if morality is part of the law, then conservatives and liberals are going to come to different conclusions. And these days, especially like as Elizabeth Anscombe and Alistair McIntyre have pointed out, we live in different moral worlds. Like they very passively, aggressively tell modernists, you can't even begin to understand what we're saying about morality because you have no clue about anything in the classical tradition. So in that context, like it makes it very hard in a divided country like ours to implement common good constitutionalism, and it was that way from the beginning. Like the founders saw that we're a divided, pluralistic country somehow trying to come together. So I guess I'm wondering what your response would be to that.
There is a few responses. One would be an easy out to say that well, actually, I'll take the historical point first, because there is debate about whether the founders themselves, and the good evidence, professors like Dick Helmholtz, Stuart Banner, Jonathan Giniapi, that the founders themselves were classical lawyers. They understood that the written text enacted by legislatures, even the Constitution, did not exhaust the content of the law. Basic precepts of the natural law, accessible by human reason, that did not require commitment to a particular sectarian creed as well. That it was expected that in hard cases lawyers would draw upon those principles. So there's a lot of evidence that the founders themselves were classical lawyers, and that originalism is the invented modernist tradition projected back in time. It would be unintelligible to the founders. So that's sort of a point on the historical. The founders themselves did it, so why not return? The easy out I was referring to is that common good constitutionalism is a speculative project. It looks to understand the nature of law as a social practice, the different types of law, and how you implement that practically is a different question. And I want to rely on that a little bit, but I would also say that the classical lawyer would point out that your legal practice already has, endemically, in hard cases, judges relying on principles of political morality to interpret underdeterminate texts. Conservative jurists draw on libertarian ones. Liberal jurists tend to draw on autonomy-centered accounts of human dignity. So they already do it. So why not try and push as much as you can to draw on true principles of political morality stemming from the natural law? It's going to happen anyway, so you might as well orient it to the speculative truth of the matter. A student asked at the seminar that Dr. Vance was so good to let me sit in on, what if judges mess things up? And another easy out is to say you don't need you don't need judges to do this. The natural law tradition is very capacious about how you organize these things prudently. So if it was thought that the Supreme Court or judges or jurists were an impenetrable barrier to sound classical legal practice, then you could think about reforming the courts as well. But I'll sum up by saying speculative comes first. The truth of the matter comes first, and then how we implement it practically has to come second.
Let's pass this down.
So this was actually going to be the question I was going to ask earlier.
I've been waiting for this one.
Yeah, so I was basically wanting to ask you if this is what the summing up the issues with originalism and also just the good points on constitutionalism, common constitutionalism, is that originalism restricts itself to only using the text alone to interpret the law. That's what it's supposed to do on paper, but in reality, it ends up drawing on things outside, like whatever the interpretation of the particular judge or jurist, and it doesn't have to be restricted by anything. Whereas with common good constitutionalism, the jurist has many places to draw from: the text, natural law, and other law as well. But it is, unlike originalism, it is limited to only the common good. Is that correct?
Yeah, I want to tread. Originalism is such a sprawling family of theories that if you say something general like originalists think X, you get angry emails saying, no, this family doesn't. But say original public meaning, the kind that judges like Justice Scalia, late Justice Scalia, or Justice Thomas, or I think Justice Barrett would use, I think they would say that they try and restrict themselves to social fact sources like text, and as they can understand the social fact source, historical source of how that would be understood by the reasonable person. So I think that's how they would characterize it. But some natural law originalists would say maybe they do consider other things, but that's the one that dominates. I would say they do think that. Whether that holds in reality, I think no, because when in a hard case you have to decide what level of generality do you understand, even if you're trying to give a original public meaning. Is it the original public meaning of the ratifier, the reasonable citizen, the drafter, and how abstractly do you, if you say it's the reasonable person, how abstractly do you understand liberty, due process, separation, legislative power, executive power? Do you apply it like that citizen would apply it in a given case, or do you take the broad principle, and then how capaciously can you adapt that in new circumstances? So I think in practice what judges do to solve that gap, bridge that gap, is if you take cases involving the separation of powers, I think is a good example, like the Obamacare case, or cases on delegation of power from Congress to the executive. Judges end up saying, okay, well, the founders wanted to protect individual liberty. That's the purpose of the separation of powers. That's the principle they want to protect, to prevent power accumulation. So, but that, that is drawing on normative argument. That's not in the text. That's you're drawing on the idea that the purpose of government is to protect individual liberty, and a good way to do that is to prevent power concentration. But that's drawing on arguments of political morality. So they say that the method is social fact, text, and history, but in practice it inevitably involves drawing on principles of political morality. The classical lawyer would say, well, yes, they would be open about doing that, so that I think that would be the difference. And yes, I agree that limits on, there are, if you're drawing on principles of use to do interpretation, then the nature of the natural law itself would put limits on what kind of principles you could apply in, could draw on. The natural lawyer thinks that the natural law just isn't what you tend to, pull out of your head. It has a metaphysical realness that is ascertainable by reason.
Hi, thank you for coming. You mentioned Obergefell at the beginning of your talk as one of the turning points, turning point cases. And as you were going through the bases of natural law, you were also talking about how we're naturally inclined towards certain things as sort of a base experience of what these basic goods are. Putting those two together, what if somebody in the year 2022 says, I am naturally inclined towards somebody of the same sex, let me get married? What is the amicus brief that a natural lawyer would write in the year 2022? Not speculatively how they would argue, but philosophically. What is the amicus brief, or is such a thing impossible in the year 2022?
In my talk, I invoked the caveat that I didn't want to go beyond my professional competence as a public lawyer. I'm going to invoke that again and say I don't want to go beyond my competence as a public lawyer by getting into the natural law weeds of bounds of marriage and things like that. If you don't mind, I feel like I would be stepping into moral philosophy, and I just make a big embarrassment of myself in doing that. But I would say the classical tradition is emphatically a framework, and people will, if everyone's arguing within that framework, I'd be delighted, and reasonable minds will differ and argue back and forth. It's not like a bullet point list of, a checklist of positions on cases and precedents. People will, working within the same tradition, reach quite different conclusions. There will be cases where there are certain things that you can't plausibly square, obviously. Like, you can never say the intentional taking of life is, dandy with the natural law, but many other precepts are more open-ended, and reasonable minds will disagree. That's a bit of a vague cop-out answer to your question, but I do feel like I have to invoke that competence caveat.
All right, let's do one more question.
Thank you very much for your talk. I was just wondering if you could leave us all with an example of someone, ideally from American history, that we might be familiar with, who you would say exemplifies a common good constitutionalist approach best.
I don't want to invoke the competence thing twice in a row. That seems like bad form. There's good work done by Professor Vermeulen writes about how the classical tradition has deep. He doesn't base the foundation of his argument on the fact that, the founders were classical lawyers like Justice Chase or James Wilson or judges like that. So we should be as well. He doesn't base the argument on that, but he does pick up arguments developed by people like Dick Helmholtz and run with them. But he would argue, and people like to Moncline, that there is people like Abraham Lincoln or Wilson and Jefferson, they all regarded themselves as classical lawyers. They understood that written enactments, statutes, constitutions did not exhaust the content of the law. They were part of a wider body of law in the community that constituted basic principles of use in the natural law as well. I'm disappointed I can't think of a... Kevin, would Abraham Lincoln in your mind be one such...
Of course. Yeah. Abraham Lincoln, James Wilson, those are all great characters.
I said Wilson. I knew
Yeah.
I remember that name from somewhere, but I'll go
What
with...
about an Irish or a European jurist that you particularly admire that we should look up?
Yeah, Judge Seamus Henchy, Judge Brian Walsh, Judge Carulu Dollig sort of spearheaded a renaissance in Irish natural law thinking in the 1960s. They're worth looking up. I like that question. That was easy to answer. But I'll go with Abraham Lincoln. That's always a safe bet.
That's a good answer, here in Atchison. All right, well, please join me in thanking Conor Casey.